Hi, this is Victor. I'd like to talk a little bit about why officers don't necessarily have to give Miranda rights. Almost everyone's heard Miranda rights. They are briefly, you have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you cannot afford an attorney, one will be provided to you. Simple. A lot of defendants expect the officer to read them the Miranda rights once they're taken into custody, but most of the time they don't. The reason is that there's two elements that must be met before Miranda is required: custodial and interrogation. Custodial means that the defendant must be in custody. There must be some restriction on the defendant's liberty to make a reasonable defendant think that they are not free to leave. Officers often get around this requirement by simply telling the defendant at the start of an interrogation, "You're free to leave." Say, they'll ask them, do you understand, if you want to terminate this interview at any time, just let me know and you can leave. They will say things like, you drove yourself here to the police station today? And the defendant will say, yes, I drove myself here. They will often let the defendant leave during the interrogation. Did you want to go out and get a bottle of water or something? Would you like to get a soda from the machine? I'm going to do a couple other things. While you're doing that, they will allow the defendant to leave during the interrogation briefly, or at the end of the interrogation, just to prove that the defendant was not in custody. Often the police will bring a defendant down to the police station, explain to them that they have the right to leave at any time. They will conduct a full, long interrogation, maybe hours long, and then at the end, they let the defendant leave. Now, they may arrest him a few hours later. They may arrest him as he leaves the police station, but they'll let him leave just to show that it was not a custodial interrogation. The second part, we have custodial. The second part is interrogation. An interrogation is when the police officers are asking questions of a defendant or of a suspect. When the police officers are asking questions meant to elicit an incriminating response. Spontaneous statements by a suspect don't count. Statements between two suspects, they don't count. They're not part of an interrogation. An interrogation is police officers asking questions meant to elicit incriminating responses. A common scenario, the police officer will arrest two suspects. They will put them both in the back of a police car, turn on the air conditioning, and then the officer will go back and do some paperwork, look through the crime scene, leave the two defendants, the two suspects, in the back of the police car, and they'll talk. They'll start talking about the crime. They'll say, did you hide the drugs? Did you hide the gun? And these are not taken in violation of Miranda because it is not in response to police interrogation. They're spontaneous statements. They're conversations between two suspects, but Miranda is not required, and the statements don't violate Miranda. So to sum it up, before Miranda rights are given, two elements must be met. The suspect must be in custody, and it must be an interrogation. Thank you.